Salute, pledge allegiance to the flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Roll call, please.
Sorry about that. Okay, Director McLaren.
Here.
Director Hernandez.
Here.
Director Martin.
Here.
Director Urasic.
Here.
Director Harris.
Here.
Peter Thompson.
Present.
Arden Wells.
Here.
And Craig Parton.
Here.
All present.
Very good. And Arden, can you hear us okay?
Yes, I can. Thank you. Can you hear me?
Hear you very well.
Great. Thanks.
And is there a motion to adopt the agenda?
So move.
Motion made by Kathy,
Second.
second by Derek. Is there any discussion? Hearing no discussion, all in favor of the motion to adopt the agenda, say aye. Aye. All opposed? Motion's carried unanimously. We're now on public comments for non-agenda items. Go ahead, just state your name and take your 3 minutes.
Good morning, Keith Lemieux. I'm speaking on behalf of the Public Entity Steering Committee. I don't know if this is the right time for these comments, so I know this is for non-agenda items. I want to comment though on the memorandum that's attached to Craig Parton's discussion item later. I don't know if you guys will do public comments at that time or you want me to do it now.
Craig, is that in public session?
I'm going to have the memo as part of my presentation, but you're welcome to comment now. I have no problem.
Okay. Well, the public, the steering committee does take issue with the legal conclusions in the memo, and I can describe that in a minute, but we have a request. And so I'll start with the request and then I'll go back and explain the issues. The request is that the privilege that Mr. Parton references in the memo is a privilege that the board has the capacity to waive. And so what I would request and what the steering committee is requesting is that you put an agenda item on the next meeting to discuss that memo and whether or not it's appropriate to waive it in the context of the settlement. So that's the request. So the request is for a future agenda item for the next meeting. I don't necessarily need to go into detail here if you're going to have that agenda item, but let me just say that the basis for our disagreement comes from the fact that this entity is not a public entity. It's a creature of agreement by the parties that have representatives that are sitting on the board. That while it says that the agreement says we're going to follow the Brown Act, that doesn't necessarily mean we're going to follow every Attorney General interpretation of the Brown Act that applies to a public entity. And because there's a key difference between the Brown Act in this context and the Brown Act in the context of public entity, and that is the agreement to use the Brown Act itself is an element of an agreement. And when you're interpreting an agreement, you have to interpret it in a way that doesn't frustrate the overall purposes of the agreement. That's something that's not present when you're just talking about a government entity following the government code, and it's not part of the AG's analysis every time it analyzes the Brown Act question. In this particular case, we would argue that this interpretation, this use of the Attorney General opinions frustrates the purpose of the agreement, because in order for the public entities to act, they need to brief their member and receive information from their member. And so, it frustrates the purpose of the agreement. And I don't think the contract should be interpreted in a way that frustrates the purpose of the agreement. Another point I would make is that in the ordinary context where you would have this confidentiality necessary for closed session has to do with making sure you don't waive an attorney-client privilege for third parties. But in the context here, we've got parties that have acted in the past. This is ongoing litigation. The court has continuing jurisdiction. The parties that have come together through this Watermaster process, the stipulating parties, have already acted together through common interest privilege through phases of trial. So the idea that a privilege would be waived, it's just not present here the way it would be present if you were talking, you know, a genuine third party to the lawsuit. These are, you know, so again, there's a lot more going on that really wasn't analyzed in the memo, and the public entities would like the opportunity to talk about it some more.
And Keith, can you specifically say what agenda, how you want the agenda item to read, just to clarify for us?
I think, I guess it would be consideration of waiver of allowing public entity steering committee to receive information regarding closed session matters. So what we would propose is that, you know, the steering committee meetings themselves are closed meetings. They're not Brown Act meetings necessarily. So we could, or if they were, we could have our own closed session, I suppose. So we could keep the confidences, but the communication would be leveled back and forth. We understand that you guys don't want to have 100 attorneys in the room every time you walk back there. And, you know, we've asked for that. You guys have said no. This now frustrates us completely because we can't even know what's going on. And so that's why it's so important to us.
We're just trying to keep down billable hours.
You say that like it's a good thing.
To some people it is. And I would imagine that would also affect ABAC and the landowners too, right?
Yeah, sauce for the goose.
So it should be open to just, the agenda item should be a discussion of the entire, how confidentiality would apply to our closed sessions with the other members, all members.
I think so. And I don't know, I know that there's been some cooperative filings going on lately in front of Judge Komar. And there must be some communication, I assume, between Watermaster's attorneys and the attorneys for the other parties that are sort of working jointly together on things already. So I would just think that this would be essentially an extension of that.
And just brainstorming with you, we've had the attorney committees before on some of the different motions and things. Could this get solved through an attorney committee of all of the members in some way? Or you think it's broader than that?
Well, the specific concern that I'm addressing is the fact that Kathy and Carolina come back to our steering committee and can't talk to us about things.
Yeah.
And so we want the ability to have that discussion at the committee, as a consequence. For example, Brent and, even Dennis can't get information. And so that then when we instruct them, we would like this or that point, we're missing a part of the picture on things, and I don't know exactly what's going on in closed session, but just from the filings, I can see that what's happening there might implicate public decisions that you guys are making that we're having to advise them on, particularly with regard to cost recovery and so forth.
Yeah, I get it. I think it's good to have on the agenda. And did we get what we need on the agenda? And it would be broader than just the public water suppliers. It would apply to all of us.
I mean, we would still like the opportunity to have our lawyers present during the closed session. Correct? We didn't talk about that specifically, but I think that's still our request. We know that's been denied. We certainly, if that's not possible, we need to at least be able to talk to them.
Understood. No, I think it's a good
subject. I mean, if the board's willing to consider the other point, which is, on occasion having the attorneys present during the closed session, that's something that we would ask of too, if you want to add that to the closed session item.
Just trying to keep billable hours down for all the parties.
So I think we've agreed, we've heard what the item would be, right? So I think that could be part of the discussion.
Of course, yeah, I brainstorm the whole thing and.
Yeah.
Yeah. Oh. Thank you very much. You're welcome, Pete. I was just teasing you. Any other, public comments?
Rob, it's John Eucastet.
Hi, John, how are you?
Question.
Yes, sir.
Good, how are you?
Good, thank you.
I have a question for Carolina Hernandez from District 40.
Go ahead.
Is that all right?
Carol.
Yes, sir. I can hear you.
Okay. In 2003, you did a storage and recovery project EIR, okay? District 40 did. I know we're going back a few years on this one here, but in that time you had put in that environmental impact report, you was putting in about 20 wells that were injection and extraction wells in the Lancaster subbasin. Whatever happened to that project? And it's my understanding that there hasn't been any injection wells put in place. So and I'd like to know how many extraction wells have been put in off of that environmental impact report, and how many of the wells were put in the deep aquifer.
Well, thank you for, I'm sorry, please continue.
And that's about it. Would be the question, what happened to the project, and how many of the wells that have been drilled, and how many wells were drilled in the deep aquifer.
Understood. So thank you for the question. And since this is a very specific question to District 29, I'd like to address it offline and maybe get information.
No, not 29. District
40. So this is, but because it's specific to District 40 and not the broader issues of today's agenda for the Watermaster, if I could get your information and have the discussion with you offline, I'd be happy to.
Okay, and you can get that information from Dean Estefio. He's got all my information. It's John Eucastet.
Okay, thank you.
Thank you.
Thank you, John. Any other public comment? There ain't no public. Oh, is there anybody? Wait. No. That brings us to the consent agenda. Financial report, month ending 2025, payment of bills through March 13th, 2025, and minutes of February 26th, 2025. Board meeting. Is there a motion to approve the consent agenda? Motion made by Kathy.
Second.
Oh, it was close. I think it goes to Carolina. Carolina made the second. Is there any discussion? Hearing no discussion, all in favor of the motion to approve the consent agenda, say aye. Aye. All opposed? Motion's carried unanimously. We're now on advisory committee report. Dennis. Good morning.
Good morning.
How are you?
I'm all right so far.
All good. Me too.
The memo should speak for itself on all the action items, with the exception of 11B. There was a typo there and didn't have Mr. Ramirez's application listed, but that was it was on the advisory committee agenda that way. So the recommendation for approval of that application stands.
So that's on 11B. You just had the wrong. I see. Understood.
And then other than that, there is continuing concern from the committee about resolving or working through the conversion of 10-year carryover to storage. And there's a number of suggestions in the memo, to that effect.
Great. And I think that subject is going to come up very quickly. I think Craig's going to be ready. We'll start having it on the agenda at the next meeting, Craig, and start working through it. Okay.
All right, thank you.
Thank you. Any questions? Hearing none. We're on item 8. Consideration possible action to approve an amendment to the memorandum of understanding with Antelope Valley East Kern Water Agency to serve as Watermaster Administrator for a fixed term. And I believe our general counsel will talk about that. Right?
I think the administrator is going to start off on it.
I'm sorry, Peter. Go ahead.
My apologies. I was not anticipating that, but
Okay, that's fine.
so you do have the amended MOU, and I know staff is comfortable with it in its current state, and we're happy to take questions on the MOU. And with that, I'll turn it back over to you, Craig.
Yeah, then there's some redlining as to exactly what the amendments have been since last month. And they were basically to address 2 issues. One, cost recovery by AVEC, so that the full cost of serving as administrator is being recaptured. And there is the conflict of interest issue that's addressed in the new language. So this is a potential action item. It depends what the board wants to do. Wants further amending, wants other options, wants to vote. Totally up to you. We do have a resolution that captures the intention to move forward with the MOU. So this has been on the agenda, I believe now 3 separate times. So I think we're all fairly well aware of what the issues are.
Okay, discussion on the MOU.
This is Angelica.
Go ahead, Angelica.
First of all, Craig, thank you for the memorandum. It's very helpful. I still think it doesn't address the concerns that I had, which is being transparent and following the same procedure that we had with the other interested parties prior to this, and that would be submitted an RFQ, RFP to the board, to the Watermaster board, so that we can follow the same process and make it fair and transparent. So I don't know how long it would take AVEC to be able to submit RFQ and RFP. Maybe that's a good question for the AVEC staff. And I insist that that should be the process that we should follow.
Just clarification, Angelica. If you want the RFP process to be followed, that would open it up to everybody again. Is that your intent?
That's correct.
Okay. Okay.
It's certainly an option the board has to send it to an RFP process. We've done that before, but there may be other candidates, different change in circumstances as to why we want to do that for openness, transparency, and to get a competitive bid. So totally understandable if the board wants to go that direction.
Thank you. Derek?
And I know that wasn't a motion, Angelica, but I would second that for a lot of the same reasons. I think we've gone through this process. It was not successful in selecting one. I think it, at that point in time, AVEC was not interested in submitting to that. They seem to be an interested party now. I think just for transparency as well as just protocol going forward, it's the right process to do, and would be behind that as well.
Okay, further discussion? Keith, are you approaching? Anybody else on the board? Discussion first? No? Keith, go ahead.
The Public Employee Steering Group has not had a chance to discuss this proposal. It's the first we're hearing it, but I just thought it would be worth mentioning, so presumably if that were to happen, then AVEC would obviously continue at least for some time as interim. And I know the public entities have a concern to make sure that the costs are properly apportioned, and the new language in the agreement before you takes that into consideration. I would express a concern that if you don't move forward with some kind of agreement with AVEC, then that language will not be included. And I don't know. I'm just pointing that out to our group because I know it's been an issue for our group that we have cost accounting, and this could create a little bit of a, I don't know what, chicken the egg problem or something if we continue as is without that language, at least for some time.
Keith, specifically where in the MOU are you looking at?
I don't have it open in front of me, but my recollection from our discussion was that there's some new language included that talks about cost accounting.
Yes, it's item 3. It's called billing and cost recovery. And it's on 35 of our packet. And I believe there was also a clause regarding termination. And then number 2 was staff conflicts of interest.
Yeah, so I would just point out that those terms are important to the public entities, and the unfortunate consequence of what you're suggesting is that we continue to move forward without those provisions, at least for some time. And so maybe if there's some way to incorporate those provisions into the motion, if that's where the landowner representatives want to be.
May I comment to Keith?
Sure.
So I guess that my point would be is this was the process we were always going through, was a temporary MOU that was allow an RFP process, right? That process failed. That doesn't mean there shouldn't be a second process in place. So I guess a question that I looked at Craig is, don't we have an MOU in place? Has it expired? And if it hasn't expired, if it's the agreement of the board to continue with a startup of another RFP, it would just be that same process.
Yeah, we have an RFP in place for
MOU, not an RFP.
An MOU in place, right? And that's mentioned in this primary agreement. I'm not sure we can parse it such that we get an MOU with certain provisions in it and reject the primary conflict of interest language. I don't know what the board wants to do on that. I think that will get overly complicated.
Yeah. So maybe add some clarity. I mean, my position would be is the MOU would stay in place as it exists, and that we would reinitiate an RFP process. So that's my recommendation, and to answer some of Keith's comments.
I want to elaborate a little bit more on that. So what I understand Keith to be saying is that what was presented in our packet today as an MOU, not only the time frame associated with the MOU, but it had other what seemed to be significant elements associated that are of importance to public water suppliers. And so the question would be, if this board was to decide to move towards RFP, would we also consider or is it even possible to consider amendments to the existing MOU to also incorporate the comments that were put forth before our board today? So I don't know, and to your point, this MOU was made, or was presented, obviously, with talking with AVEC and with their understanding that they were agreeing to an MOU, not only with these changes, but changes in the duration. So I feel like that would need to go back to ensure that the other party to this MOU, which is AVEC, would be open to that.
Open to that discussion. I guess I'm interested in hearing if AVEC was even agreeing to this structure as it sits today.
So I'm hearing everything, and I'm obviously this hasn't gone to our board nor the advisory committee. The advisory committee, and Dennis, I know it speaks for itself, but it looks like it was a vote of 9-0-2, so 9-4-0 against and 2 abstentions for the motion recommend the approval of the updated memorandum of understanding. So if that's the case, and now there's a request to go through the request for proposal process, I think all that has to go back to the advisory. I mean, I'd like to hear what the advisory committee has to say about that, because if we're looking at 9-2 abstention, that covers the RFP part. About the billing part, Peter, you want to weigh in on that?
I'll just weigh in, and
obviously we would have to talk to our board about it, but.
Right. So that would be.
And maybe Matt should talk about it, not you. Because you're the administrator.
I would just say that would have to go back to the board for consideration of an amendment to the current MOU that we have. So,
and just as one member of the board and a member of this group, I would not have a problem with that, but I can't make that decision here. And none of this is agendized, and it hasn't been to the advisory committee. So we can go forward and vote on what is on the agenda and see what happens there. And then obviously we've had this discussion, and if either one of you want to put on the agenda next time, let's see how the vote goes. And then you're open to put on the agenda whatever you want so that it can be discussed with the advisory committee. I think that would be the proper way to go, and it's what we've done in the past.
I guess it would, may I speak?
Sure.
Sorry. Another possibility, I guess, is given that we're kind of moving forward in an uncertain state, maybe AVEC could consider whether it would voluntarily agree to abiding by the new terms that are in the proposed MOU, even if it's not technically in the existing MOU. That might be good enough to sort of satisfy the issue while we go through the RFP process.
And Keith, I can see presenting the billing question, but the termination question about a 4-1 vote or where AVEC can't vote.
Yeah, I'm really talking about the billing question and the
that's what I'm
conflict
thinking.
issue.
Yeah, I would have no problem with going back to AVEC and putting that on our agenda to discuss. I don't personally see a problem with it, but I haven't had time to vet it out. The board did not act on this MOU. They were going to wait to see what happened today. But the termination clause, obviously that's going to have to be worked out with everybody's input on that. And
I don't think that AVEC could unilaterally change the termination anyway. But what I was thinking is AVEC could, for example, say, we've read these 2 sections and we will voluntarily comply with them on the existing MOU during the pendency of the RFQ process if the board decides to go that way. And if not, then they can be incorporated into the new MOU if we decide to move forward without the RFQ process.
Well, I'm kind of confused how we're kind of getting deep involved with this when we have one thing agendized and we're completely changing it now.
Yep, Kathy, that's the point I made. So I understand.
Well, and I'm not suggesting something that would require board action. It would just be something AVEC could do as a suggestion.
I'm just saying, this is like not what I was expecting to happen and to go into, because it's definitely something we haven't taught for the advisory board. And so.
Yeah, there's no notice.
Yeah, right. So, yeah, I understand about, let's just see how this process works. I've heard whatever has to say, and then we can sort through it. But I agree with Kathy. We have on the agenda the resolution approving the First Amendment to the Memorandum of Understanding with Antelope Valley Eastern Water Agency. So I'll take that. And then in the general discussion regarding that motion, if that motion fails, then obviously there's other direction we can go, right?
Thank you very much.
Thank you, Keith.
And I think the reason we're even here today is because at the last meeting, our public water suppliers had made a suggestion for some of these things. And that's how we're even here from last meeting to this. And
Just to move it along, let's just take the agenda item, get discussion, and then we'll go from there.
Okay.
So at this time,
Are you allowing further discussion at this time?
yeah, or after a motion's made, whatever you want.
Just for, I think prior to a motion, I know this was agendized in the ABAC board packet. Can you just, or you or Matt, give us an update of if there was action or what was
Yeah, I
taken there?
think you were on and Helico was on it.
For the public.
And listen to us. What we decided at ABAC, thanks for clarifying. What we decided at ABAC is just wait to see what happened today to see if we're going to approve it. An item I brought up at ABAC was if, and I actually asked Julie to comment or think about it, but if we're changing our rules and regulations to allow for a 4-0 vote to terminate the administrator, then with ABAC abstaining, then we should also consider a 4-1 vote for hiring an administrator. That was the comment that I made at ABAC. But let's see how this goes. I mean, I can discuss that now. If you're asking for ABAC, and I don't have a problem with that. I understand if 4 votes did not want ABAC as administrator, I'd probably vote in favor of that too as the ABAC rep. But if you're going to change what we've been doing, and have advocated changing to, a 4-1 vote or 4-1 abstention because we've had that problem in the past. So this is a good time for me to bring that up again. I personally feel whatever action we could take to make it a supermajority rather than unanimous on everything. But this is the first one where we're being asked to move off of that. I've always advocated for that. I don't have a problem with it, but then let's expand it to a 4-1 vote to hire an administrator. And Julie, did you do your homework? Do you want to comment on it? Julie Kyle is coming up. Thank you.
I don't have a lot of time to talk with Galen about it, but I know that we have been staunch in keeping a 5-0 vote. We feel like that's our only chance of staying in the game. We really do.
So how do you feel about the changing of the MO2 for ABAC not to vote on termination of the administrator if ABAC is the administrator?
Personally, I don't care for that. I think ABAC should be in it. And I know other people do, feel differently about it, but once again, I know I sound like a broken record, but for 7 years, ABAC has taken care of us. And this year again as an 8th year. And we just have not had any issues.
I appreciate it.
Thank you.
So those are my comments. Any more discussion on this? Okay. So we're on item B, resolution R2508. Is there a motion to approve resolution R2508?
So moved.
Motion by Kathy. Is there a second?
Second.
Second by Carolina. Is there discussion? Hearing no discussion, all in favor of the motion, say aye. Aye. All opposed? No. So it looks like there's 3 yeses, 2 nos. Motion fails. So what I would suggest next, and I've heard you, I think I'll just take this action, see if this is helpful for you. I think I'd like to put on the agenda for the next meeting, if the board should do a request for proposal for administrator. Do you want any more than that, or is that enough?
Personally, me, I think that, and, you know, and I hate to bring this up, but I looked at Craig and the chair is, you know, we seem to be going round and around in this and not finding alignment as a board. Is there a discussion and maybe a conversation that Craig has, or just preparing a memo of taking this to the judge and, you know, having him make the call? I think we need to ask him what that call is. I'm not sure I've synthesized that in my mind, but I would, you know,
well,
maybe bring that to the table.
Yeah, understood. I think that would be a discussion next month if we can't come to a decision on what we do next.
Yep.
So
I'm happy to do that. I'm kind of, as the last resort, want to go to the judge and ask him to settle this problem. I'm curious whether it might be a solution to do the RFP process. Is that initiating that process? Does that bring unanimity to the board in terms of what they can support?
again,
If the MOU is
yeah.
not amended.
It's not on the agenda. I think let's put it on the agenda, which I just did. I want to hear the advisory committee's comments. I want the public water suppliers to have their meeting, landowners to do their thing, and then come back with all suggestions of what to do. And then we'll figure it out. We've had a good run, but 8 years, Julie, of getting almost everything decided. So, and we've been able to work it out. So let's try to do it. The other thing, Keith, to address your concerns, Matt, if you could talk to our president and see if we could put on the agenda the new billing procedures that are requested while all this is pending, so we could discuss it and I'd have an answer for everybody at the next meeting. Would that be okay? Thank you. Does that solve all of our issues right now? Yeah. Great. Thank you.
And just and you're wanting to agenda, I guess, postpone this further conversation. Is just based upon not being agendized, just kind of procedurally?
No, Derek.
I'm just trying to lean into what Craig is saying and kind of to push this off.
I think we have never taken action on a non-agendized item without running it through all the different committees. So that's my reasoning.
Okay. Okay, thank you.
Is that okay? Okay. And Keith, did I solve your group's concerns? Okay, great. Just here to please. So that brings us to 9, consideration possible action to accept and file the replacement water plan submitted by the Antelope Valley State Water Contractors Association, which satisfies the Watermaster's replacement water responsibilities for replacement water assessments collected as of November 30th, 2024. That's a tongue twister, and Peter, go ahead.
That is, I'm a little more prepared to discuss this one. So, so just a refresher on the process. So replacement water is assessed by admin staff and the Watermaster engineer every year after taking in all the production reports. That's compiled, that's brought back to the Watermaster board for approval of a letter to go to the AV State water contractors requesting that replacement water. That letter was sent. The AV State water contractors responded to that. Each of the agencies, Little Rock, Palmdale, and AVEC, their general managers looked at and approved a plan for releasing imported stored water to meet those replacement water obligations, and then apportioned the money from the replacement water assessments accordingly with that water that's released. So in front of you today, see, Holly, can you move to the next slide? We've got the breakdown of where that water is, what water is being replaced by which agency, and where it's being released at in the different storage areas. And if we go to the next slide, you can see an overview of the map showing the replacement water assessments where the different pumping occurred, and then also where the boundaries of the agencies are, as well as the release points for that water. So at this point, we're just looking for approval on this plan from the Watermaster Board, and then once we get approval, the Watermaster will cut a check to the AV State water contractors, and Arden will do the accounting to release that water to the basin for those replacement water assessments. So I'm happy to answer any questions you might have.
Questions, Peter? Hearing none, and you want a motion for approval?
Yes, please.
Is there a motion to approve the replacement water plan submitted by the Antelope Valley State Water Contractors Association per agreement dated October 23rd, 2019?
So moved.
Motion made by Carolina, second by
Second.
Kathy. Hearing no discussion, all in favor of the motion say aye.
Aye.
All opposed, motion's carried unanimously. And that brings us to discussion direction on new producer compliance. And Peter?
All right, so you're gonna hear me talk a lot about new producers, and there's gonna be some overlap. We're getting ready to send out invoices to the new producers. And last year we went through a lot of effort reaching out to non-responding new producers. We have some remedies for that coming up. But one of the things we wanted to address is to get approval on how those invoices will go out to the new producers who have been delinquent with their production reporting. Staff is recommending, let's have Holly, can you advance the slide? Staff is recommending that we send out those invoices with a defined grace period to make an appeal. So what the most frequent appeal would be is that a new producer has not drilled a well. They're going to receive an invoice for their maximum replacement water assessment, and they're going to have 30 to 90 days, whatever the board decides, to make that appeal. And then we would also include the information about what is necessary in order to make a successful appeal to the Watermaster. So we feel like that is good to provide a grace period as we're starting to work through some of the issues that we've run into with new producer reporting. We think that this would be appropriate. So if the board feels that it's appropriate, a motion to approve a grace period for new producer invoices with delinquent production reports is what we would be looking for.
I'm a little confused.
Okay.
So I got the memo, understand that. Tell us exactly the action you want us to take in the form of the memo. It's not a resolution, so we're just approving
a defined grace period.
A defined grace period?
Yeah.
And that's all the motion needs to be?
That's all it needs to be.
Okay. Is there a motion to approve a defined grace period for the new producers? And Helika made that motion.
Second.
Carolina, second that motion. Is there any discussion? Hearing no discussion, all in favor of the motion, say aye. Aye. All
Aye.
opposed, motion's carried unanimously. Thank you, Peter.
All right, thank you.
That brings us to item 11, consideration possible action on new production applications. And that's going to be Arden.
Hi, good morning. So there are 2 new production applications this month, and they're both for domestic use. The first one is for John and Angela Claiborne, and this is in the West Antelope sub area, and it's for a single family home with 3 bathrooms, irrigated fruit trees and grapevines, and a few livestock. And we found the potential for material injury to be negligible, and it was unanimously recommended by the advisory committee. Are there any questions?
Any questions? No questions, Arden. So you want a motion to approve resolution R2516, I would imagine. Motion made by Kathy. Is there a second? Second by Hannah. Elika, is there any discussion? Hearing no discussion, all in favor of the motion to approve resolution R2516, say aye. Aye. All opposed? Motion's carried unanimously. We're now on R2517.
Excuse me, Rob, can I get you to go back one more? I'm sorry. On the motion that you made for the new producer compliance, what was the grace period going to be? 30, it says in the memo anywhere from 30 to 90 days.
I'm just following Peter's direction. He said grace period.
Yeah. So we'll do 60 days.
Do a 60-day, okay, thank you. That way I can put in the minutes.
60 days.
60-day grace period.
Everybody good with that?
Yeah. Yes,
Okay.
thank you, sorry about that.
I think we would leave it up to the administrator, but it's good for
It
us
needs
to
to
all
be
know 60
defined.
days. Now you confused me. Have we already voted on R2516?
Yes.
And it was approved unanimously, and now we're on R2517.
Yes.
I'm getting old. You can't interrupt me like.
You're moving fast.
Thank you. Arden, go ahead with R2517.
All right, this application is for Mr. Rodolfo Ramirez for 0.5 acre-foot per year of new production in the Willow Springs sub-area. And this is for a single family home with 600 square feet of landscaping with the estimated use of less than 0.5 acre-foot per year. And similarly, the potential for material injury we found to be negligible, and it was unanimously recommended for approval by the advisory committee.
Thank you. Is there a motion to approve R2517?
I move.
Moved by Carolina. Is there a second? Second by Derek. Is there any discussion? Hearing no discussion, all in favor of the motion to approve resolution R2517, say aye. Aye. All opposed? Motion's carried unanimously. I really like how we're having the public water suppliers working with landowners on motions and seconds. That feels good. Let's go to consideration and possible action on transfer application. And Arden, that's still you.
Yes, so these 3 applications were considered last month, and it was requested that the Watermaster engineer that we adjust applications first off to change it from the water being considered an investment instead to have the water for use at our TS Orchards parcel with the clarification that for the current material injury analysis, the production at these parcels are limited to up to 1,800 acre feet per year. And we also included hydrographs in the applications to show that the material injury analyses for this volume at these parcels remains still up to date and applicable. And so with that, we found the risk of material injury to be negligible. And the advisory committee said that the adjustments to the applications addressed their concerns and unanimously recommended all 3 of these applications for approval.
Okay, any discussion? Carolina?
Arden, as I recall, there was a discussion in one of and I just want to confirm, I think this is what happened, but we wanted to revise the wording regarding investment purpose. Am I remembering that correctly?
Yes, that's correct.
Okay, and so that was noted?
Yes, so we removed all mention of investment purposes and noted that the application said this is for use at RTS Orchards parcels, and then did conduct a material injury analysis.
Thank you.
You're welcome.
Thank you, Art. Any other discussion? Hearing none, is there a motion to approve resolution R2511?
I move.
Motion made by Carolina.
Second.
Second by Angelica. Any discussion? Hearing no discussion, all in favor of the motion to approve resolution R2511, say aye.
Aye.
All opposed? Motion's carried unanimously. Is there a motion to approve resolution 2512?
So moved.
Motion by Kathy. Second by Angelica. Is there any discussion? Hearing no discussion, all in favor of the motion to approve resolution R2512, say aye.
Aye.
All opposed? Motion's carried unanimously. We're now on resolution R2513. Is there a motion to approve resolution 2513?
I move.
Motion by Carolina.
Yes.
Second by Derek. Is there any discussion? Hearing no discussion, all in favor of the motion to approve resolution R2513, say aye.
Aye.
All opposed? Motion carries unanimously. Administrators report, update on administrators' activities. Peter.
All right. Next slide, Holly. I just
Step it
want
up, make it exciting.
I was working on a dance, but it's not perfected yet. So just want to run you through a few key things coming up in April. So we're going to be mailing out the replacement water assessments, the variable assessments. April's going to be a pretty busy month. We're going to be assessing those delinquent fixed assessments also. We will be presenting the first quarter budget for actual report. We will, as mentioned before, continue the discussion on carryover water storage agreements. And as noted in upcoming, we're going to bring a list of non-responsive new producers for consideration for revocation per the judgment. So April's going to be an exciting month, so you don't want to miss that. And yeah. And let's move on to the next slide. So staff did put together a memo addressing some of the issues that we uncovered when we dealt with all the delinquent new producers in 2024. So I just wanted to summarize those, and then we'll talk about the solutions that staff offered, and then also the advisory committee's responses to those. So one of the key things we found was just in the lack of response. So the vast majority of new producers over the years have not responded to an effort to get production reports from them. What we ended up finding that a lot of it had to do with just a lack of awareness. And that lack of awareness was because well drillers were filling out the applications and they were just kind of handing it over and then forgetting about it. And oftentimes the biggest disconnect was that if they opted not to drill or they're opted not to, or it was a dry well, then they just figured they had no more obligation to the Watermaster. And that's why we saw most of the lack of response. There was also some instances of folks moving away from the property and never drilling the well and just not being able to get a hold of them. So we recognize there's a need to increase awareness with those new producers during that application process. So then the other thing that was really apparent is going after all these new producers, especially the ones that had moved or hadn't drilled their wells. It took a lot of administrative effort. So essentially you're getting, for every $10 you spent in administrative costs, you're getting back $1 in administrative assessments. And so it's a real cost sink. And, you know, as we continue to expand, it's just something to be aware of as more new producers are out there. That effort is kind of disproportionate to the cost that or to the revenue it brings back. The other one that staff feels is problematic about strictly enforcing section 14.0 of the amended regulation or rules and regulations is that it just jumps to the maximum possible penalty. So if you go after someone who hasn't drilled their well and you give no grace period, then there's almost no incentive for them to respond to the Watermaster to come back and say, hey, we haven't drilled our well. Because if they do come back, we're going to levy the maximum possible fine on them at that point. So there is just this disconnect that, you know, if we're jumping to the maximum, there's no appeal process. We may never hear from folks that we're new producers and then just failed to drill their well and don't want to produce. So that was just something that we felt like was worth looking at. Then the other thing that was a little troubling, and this a little bit putting on the AV State Water Contractor hat here, is that there's kind of a misplacement of replacement water assessments. So if you're going after folks, you're strictly enforcing that rule. They've never drilled their well, but they're going to pay 3 acre feet worth of replacement water assessment. That money is going to come back to the Watermaster. We're going to develop a replacement water plan based on the pumping that occurred, and that money will eventually go to the AV State Water Contractors. Water will be released, you know, as close to that property as possible, except for that water has never been pumped. And that just creates, we have this situation where we're not covering admin costs for it, and we're not appropriately applying replacement water for water that has been pumped. So we just felt like there was a disconnect there, and we thought there might be some solutions for that. So next slide, Holly. So some of the things that we felt like would be very helpful, and we got good support for some of these. We want to put together a page as part of the new producer application process that lists out all the responsibilities of a new producer under the judgment, and then also requires a notarized signature. So we really want to find a way to get a hook into the process where the property owner must be intentional about reading the responsibilities under the judgment. We feel like that'll help with the lack of awareness. The other one that we suggest is changing the fine for being late on your production reporting from maximum replacement water assessments to some sort of reasonable fine that could come back to administrative costs and cover those administrative costs. If you do this, then they're still going to pay their appropriate replacement water assessments. So if they pay their fine, they produce their production reports, and they pumped water, they'll still have to pay the replacement water assessments, but it'll be on true pumped water. So we feel like this helps with the disproportionate admin costs. It also helps with the reverse incentive. You're not jumping up to the maximum possible penalty right away. And it also helps with that disconnect on misapplication of replacement water assessments. This was supported by the advisory committee. I think there were comments. They felt that the $100 to $200 was too low. We put that in there because based on what we saw with the costs, that would adequately cover, that's the range that would cover admin costs for the time put in. The other one we threw out there for consideration is there's a section in the judgment that allows for domestic single family homes to be declared de minimis, and you wouldn't invoice them anymore for replacement water assessments. There's a lot of enforcement that needs to be done out in the valley, and we could probably put that administrative, legal, and engineers' time to better use going after those that inappropriate pumping that's going on out there versus going after just the domestic supply. So we just want to present that as an option that would reduce the amount of administrative effort, legal effort, engineering effort moving forward into the future. This was not supported by the advisory committee. But we just wanted to bring it up because it is in the judgment and it is the way most other adjudicated basins operate. And finally, there's a section in the judgment that allows to revoke non-responsive new producers water right. In some spots it says suspend and some says revoke. We would like to bring back a list of those non-responsive new producers, revoke their right, and essentially take them off the list. And if they are found out later on to be pumping outside of the judgment, then they can be dealt with mechanisms. So that also was supported by the advisory committee. So that you're welcome to give feedback on the memo or on these kind of abbreviated points, but those are the thoughts of the staff dealing with this issue.
Thank you, Peter. Collins? Carolina?
Thanks, Peter. So first of all, thank you, Chief, for really, this looks very comprehensive. I'm sure it took a lot of thought and through the, many, many months of work trying to tackle this issue. I can see the work that got put into it. My one question is about how we can, the last note saying notify the Watermaster if the property is sold, and how that would actually be implemented, how we could track that,
Right. I think that is always going to be a struggle, especially with the domestic well suppliers out here going on to the future. My thinking there is that we did have, I think, at least one person come back to us and let us know that they had sold their property and they wanted to appeal the process. So our thought was we would include in there that if their property has been sold, that they provide us some sort of proof. And then we, as a part of their appeal. I don't know if Angel, if you want to speak to that at all, or.
I don't really have much to add, but I think it is good to know that if a new producer does sell their property, their new production application does not benefit the new buyer. The new buyer would also have to submit a new production application showing what they want to use the water for and get approved when the material injury happens. So it is hard to keep track of all these new producers and who's selling properties, who's not. So yeah, but I think that this sheet that we put together, just stating that in that bullet, that will bring that to their attention, and they'll know that when they do sell their property, that the Watermaster is requesting that.
Thank you.
Okay. Further discussion?
I think a combination of these proposals would be very effective. And I think it would be a lot of work, but maybe checking APNs, maybe every 6 months and comparing to what you have to see if there's been any change in ownership. I don't know how many APNs we're talking about here.
Yeah, that's where we start escalating the cost pretty rapidly of going out. Yeah.
Further discussion?
So on that, the enacting section 18.5.13.2, so that's in the judgment.
Correct.
And not currently being enforced or not being applied, or?
It has not been applied yet.
So that, maybe explain to me why that's not being applied, just by no action of the board? The board could invite the Watermaster engineer to assess and declare them de minimis under the judgment. I'm
and Craig can jump all over this if I get this wrong. We've essentially been declaring that their pumping is de minimis to the judgment when we produce the new production app. We approved the new production applications with no material harm on those domestic wells, but we haven't applied that section and allowed them to be kind of voided out of having to do part of the replacement water assessments or the invoicing process yet. So I don't know, it's an option, but I think it would take some action from the board to seek that from the Watermaster engineer. That's the way I understand it, Craig.
So, and Craig, I know it looks like you're reading into it at this moment.
Yeah.
And maybe we take this back, but I mean, if this was stipulated in the judgment and the parties agreed to it, and you're calling out that there's significant economic cost relative to value, I'm trying to understand, and we've unofficially kind of followed that rule by the engineer has followed that in a sense. Why wouldn't we just document it and make it official? So
Yeah, I need to look back. I'm looking at it now, and it seems black and white and an easy call. I don't know what the perspective is that would say that that section of the judgment is not applicable now. The judgment was applicable and effective when it was entered in December of 2015. So I'd like an opportunity to go back and take a look at that section and see what implications it has for the new production regime that we're talking about.
So I'm not trying to hold up this whole
Yeah.
presentation, but maybe tabling that item to bring it back to the board. Could I suggest this? This was informational, really not action.
Correct.
So I think so we're not going to do a motion, but I think if we can give consensus to Peter and Craig, what to bring back to us for the next meeting, and we have the advisory committee weighing in, here would be my suggestion is, the item number 1 just takes, addition to our new production application. So that isn't a change of our regulations, rules and regulations. Item 2 is a change to our rules and regulations. So we could give some direction to Peter and Craig to, for our next meeting, bring back a revision based upon the consensus we reached here. Item 3, we've already asked Craig to come back and kind of explain that to us, so he can come back, and there's no action required. He can come back to explain why we have not enforced it, should we enforce it, and let us decide on that action. And then item 4 is requesting amendment to the rules and regulations. So what I'd suggest is we request Peter and Craig to go back and work on amendment to the new production report for item 1, a change in rules and regulations for 2 and 4, and to report back on item 3, a recommendation of should we enforce it? If we're not enforcing it, why not? And what we need to do. Should we include that, like 2, 3, and 4 being the same type of actionable item instead of like bringing it back in another meeting after that? I mean, to present and then. Well, we're going to need it to go before, I think for the change in rules and regulations, we need that to go before the public or no?
Yes.
So that is
we need to give notice of
that's
that.
1 and 4.
I just want to clarify,
4.
4 is not a change in the rules and regulations. We can apply an existing rule to bring back a list of non-responsive new producers and revoke.
So 4 is not a change. So the only change would be 2?
Correct.
And then how do we implement 4?
We'll bring back the list and I'll work with Craig on the appropriate memo or resolution.
Okay, so, let's start with one. So that's changing the new production application form.
Yes.
Do we have a consensus to bring that back to the next meeting with those changes to approve?
Yes.
Yeah.
Everybody good? Okay. Number 2 is a change, amendment to the rules and regulations. That would have to go through a public hearing. And it seems like the advisory committee was okay with that, except they were, and Dennis, correct me if I'm wrong. For number 2, it seems like you guys were concerned about 100 or 200 was not enough.
Correct. If that was intended to be a penalty that people would want to avoid.
Okay. But otherwise, there was consensus of your group to implement this
As an
amendment.
idea, yeah.
And did you have any discussion about what an appropriate penalty would be?
No, there was no definitive discussion on that.
Okay.
You know, could be $500, could be a percentage of what their full replacement water cost is.
And Peter's comment to us, I believe, was they were coming up with these numbers, Peter and Angel, because that is what it was costing us. We've always, I won't use the word always, the spirit of this board has always been not to overly penalize the public to recover our costs. My feeling is, if we go to the 200, that would, according to what our staff's telling us, that would cover our costs, and then that would give consensus and direction to come back to us. But I don't know what's the board's feeling on that.
So I think it really is a question of not just the recovery of cost, but what is the deterrent? So
Deterrent,
the
too.
premise
Okay,
of
right.
this conversation has been that we're not getting responsiveness.
Right.
So I too am concerned with how high it might be, but I don't know if just cost recovery is the appropriate deterrent. So I think we should consider something that might be a deterrent, but not, backbreaker.
Yeah, understood. So the replacement water assessments for a small pumper would be what, up to 1 to 3
Correct.
acre feet?
Yeah.
So and what is the current cost of 1 acre foot? 600 and
600 and just out of here, I think 32, 36.
can it ever be less than 1 acre foot? Or it could be, so it could be half an acre foot or something.
0.05 acre.
Well, their right will be higher than that.
Their rights to pump, but what they report.
What they
is Angel's
report,
talking about,
yeah.
So I'll just throw out $500 as the penalty for this and bring back a rules and regulations that have to go through public comment. So if people think that's too little or too much, we can get comments on that, but at least this would give us a starting point.
And it could also be an up to, so you have at least a range, 500 to, because there could be situations where 500 is not enough compared to what it's owed. So you can have that range flexible.
Right. I think it could be considered. I think there's one thing, if the board does consider 3, then that really eliminates the dominant portion of the issue. And then you're really just dealing with new producers that are commercial new producers that are producing a lot, and then you would put them on an enforcement list and go from there. But
so you're saying we don't even need to amend?
I do think that it should be changed from replacement water assessment so that we can appropriately apply a fee that goes back to administration costs versus water going or money going to
Money
the
going
association.
to the association. Okay, I got that. I'm just trying to get consensus on a number. We're going to have public comment. If If it comes back, they want it to be 2,000, fine. If they want it to be 250, fine. But just so Craig has something to work on, if that would be okay.
And I guess my point is, we saw when we sent delinquency notices or invoices out, those people that felt they shouldn't be paying came, right? We kind of rose to the occasion. And I think whatever we decide to do, it has to have that impact. And I think, advisory committee had a similar comment, like it's got to be painful enough that they say, hey, either I'm not using it, I'm going to come and petition, or I'm going to pay it and report from now on. It's got to hurt a little bit in the pocketbook.
And I think if I remember right, our concern was that we wanted to get away from people coming and us changing each time. So we wanted to try to get some consistency of enforcement, so we didn't, Mr. Smith comes and we approve it, Mrs. Jones comes and we don't. I think we're trying to get to a place, this is what we've decided, everybody has agreed, this is your penalty if you don't. And I guess there may always be exceptions, but I thought that was why we're moving in this direction.
And I'm fine with that, setting it. I think I supported the board for consensus of giving some waivers and reducing it. We pay our fee every time, and we report and we do everything, and I think that's the responsibility of everyone in this valley that has to. So I just think it should be commensurate to what they're supposed to be doing.
And just one comment, and then I'll sit down.
Thank you, Dennis.
Just a few minutes ago, you approved new production at half an acre foot.
Right.
So if you're going to set a dollar amount,
Maybe it should be a half acre foot penalty.
so just keep that in mind.
That's a good point. I don't care. I think we need to take some action, we don't have to take action today, just consensus of what we'd like Craig to work on.
Yeah, Peter, I heard you say something about 300. Did I mishear you? Did you throw that number out?
I don't recall saying that.
I was just wondering if that was something that you felt, because, after hearing our discussion, if you felt like that was, for example, in line with maybe what a penalty would be, like what Dennis said for absent acre foot, or.
Yeah, I think maybe just to put it in context, what we're talking about is the penalty for providing your production report late. And how much do we want to penalize someone? Now, if there's a grace period and they can appeal that, then that helps. But I know the previous discussion with the board was about a no grace policy. I think where the rubber really meets the road there, where there's the friction, is when you have folks that have not put in a well. I think we've come up with some options that could help increase awareness and increase responsiveness. And I know when Arden comes out with the app, that will help as well. And then I'll just throw out too, is if we go with option 3, then that really eliminates most of the administrative effort and the headache in the appeals when it comes to the new producers that have been historically non-responsive. So I would almost suggest that the board consider, if they are seriously considering 3, which is declaring single-family homes de minimis, that eliminates some of the pressure on the number 1, and we wouldn't be developing long lists in the future of revocations for non-response. Right. We took 3 first, and then I don't know, Craig and I could work on some language for number 2, just to convert it over to a fee, and then it could be up for consideration on what that fee is in the future.
And then you wouldn't need one, or you'd still want one?
I think Well, if we change the rules on 2, then it will impact how we do number 1.
We still want number 1 where they have to notarize what
Right.
the rules
Yeah,
are.
but that will come after any change to the rules and regulations. Just so we
And
can,
then if we decide to implement 3, then we don't need 2, or we would still need 2.
I think it would still be good to change the replacement water to a fine.
Okay, got it. And then 4 is already,
We can bring that back at the next meeting.
and we can do that
Yes.
already, right? That
Yeah.
doesn't need a change. So the only change that would require public comment is 2, where we do a fine, and then it doesn't matter. Okay, I don't care what the fine is. Somebody just throw a number out so I can put it in so we have public comment. Do we want 300, 500, 1,000? Julie, come on up.
On number 3, then we're talking about not charging an RWA? Or,
To domestic water supply.
so
only.
new production that comes in, not charging them an RWA?
That's correct.
That's right, so.
It's just for them,
Which is what?
not all the production.
Is that-
Just qualify.
Right.
Isn't it? Oh,
Two
yeah,
acre.
I'm sorry.
Is it a 2 acre?
Up at 3 acres.
I think it's up to 3.
I just want you to think about that because that's changing things.
Yeah, wouldn't that almost put new producers for residential, kind of treat them like the small pumper class?
Maybe I can help with that. I believe the new producers would still have different rules than the small pumper class. So they would still be required to submit production reports, put a meter on their well. It's just that replacement water cost that would be eliminated.
Can you bring back, so we're going to obviously try to take action at our next meeting. Could you bring back what we're actually collecting from new producers, residential new producers, and how this would impact us? Are we talking about
For the replacement water
for the
assessment?
replacement water assessment? Are we talking about 10,000, 100,000, million? I don't know.
And I guess my other request would be hey, I mean, every acre foot counts in this basin. But if this was stipulated and we are charging and we're not supposed to be, do we have exposure from a legal suit for doing something that's against the judgment?
I don't have the judgment in front of me, but I think it says something in the lines of the Watermaster engineer has the ability to deem new production for single-family homes de minimis and not collect a replacement water assessment. So it's really up to the Watermaster engineer, I believe.
It's Arden's fault.
Yeah, it's all Arden's fault.
Well, I would just say that if I'm Arden and the engineer, I'd like counsel to give me some clarity on this.
Let's shift it to the lawyer.
That's right.
I agree with that assessment.
No, I understand. This needs some reworking, some teeing up for a vote next session. And I'm very well aware that we've passed many times some very strong rules and regulations because people wanted to get the message out there. And we will advise whether we're compromising on that position or not.
Okay, I think I'm ready, and correct me if I'm wrong, everybody. Consensus is go forward with bringing back a change to the new production application that would require the notarized signature of their responsibilities, number 1. Number 2, bring back a revision of the amendments of the Watermaster rules and regulations regarding a penalty on maximum replacement water assessment And I don't care what that number says because it has to go through the public. We have to discuss it. We might start with 300 if we want more or less. We can discuss it and make that decision, but at least we would have an amendment in front of us. Number 3, we need to know, Craig, should that be enforced? Or what discretion does our engineer have? How should we implement this? Should we implement it and have that general discussion? That's kind of separate. And number 4, that was 3. And number 4, that's more discussion from us. Bring back kind of a legal opinion, Craig, on what you want us to do on 4. Is that what you want, Peter? Or?
I think Craig and I can get together. I think it's ripe for an action item.
Okay.
But if Craig disagrees, then we'll just bring it back for discussion.
So bring these back as action items next time. That's our consensus. Everybody got it?
Yeah.
Okay. And very good report. You put a lot of work into this, so we should take your suggestions seriously and make some progress. All right. Everybody good with that?
Yes.
Yes.
Okay. Good. Thank you. Administrator's report, we're done with water engineer, right? Are we done?
Yeah, we just had a slide. If you want to see the current iteration of that new production page to be notarized, that's on page 135.
You already had it ready for us.
Well, I was, you know what, the advisory committee was quick with their recommendations, and Craig and Cameron were quick with their revision of it. So it's pretty much done, but if we sit down and consider a possible revision to the rules and regulations, we'll have to incorporate that in the next draft. So, but we can move on. I think we've got our marching orders for this item.
Okay, super. Thank you. Very good report, Peter.
Thank you.
And now, Arden, it's your show.
Thank you. I'm going to share my screen real quick.
And Arden, so I don't rush you, just tell us what item you're on and I'll let you go item by item without interrupting you.
Okay, excellent. And I'll make sure that there's time for questions in between each one.
Great, thank you.
Great. So we are starting with item A, which very appropriately is our summary of new production and qualified small pumpers. So we currently have 899.12 acre feet per year of new production. This is the same as last month because 1.5 acre feet per year were approved of new production, but then 1.5 acre feet per year were revoked from 2 parties contacting Watermaster admin and letting them know that they either didn't drill their well or moved off of the property. I think it is important and relevant to just note that a lot of the new production isn't from the single family home small pumpers. There's some parties like Long Valley Road that were producing previously, and the board requested that in order to get into compliance, they become new production. And the producers who are producing the most typically are the most responsive about reporting. I could get the volume of new production that is from single family homes for next month, if that's an important item to have the number for. Are there any questions on this?
Nope, you're good.
All right, hearing none, going on to the next item this month. So item B is a review that we did this month of water levels in the Central Antelope subarea. And this is in response to a request from the board last month. Last month in the meeting, y'all approved 2 replacement wells at the U.S. Air Force Plant 42. And I've got a little star of the approximate location of that on this map. And the replacement wells were needed because the Air Force reported that groundwater levels declined beneath the screened intervals of their existing monitoring wells. And so the board requested that we look into water levels near Plant 42. So this is a hydrograph showing the groundwater elevations of a USGS monitoring well that is either on the property or just adjacent to it. And so we can see from this hydrograph that in 2022, water levels were below the bottom of the monitoring well screen. I have that as the red line going across the hydrograph. And we see that water levels declined sharply prior to about 2018. And then in general, we've seen a decline, but it's been much less drastic since that time. And I sort of have the ramp down period shown on this hydrograph. And then we went through all of the USGS monitoring wells that have been measured since 2023 and generated hydrographs for them. And then I just briefly went through each one and looked at the water level trends since 2016, so since really the implementation of the judgment, and just said, do we see water levels increasing? Do we see a declining trend? Or do we see relatively stable water levels? And I also noted for some of the wells, either there were big fluctuations that were probably indicative of well activity from nearby wells causing fluctuations, or there weren't enough data. But for 13 of the wells, we weren't really able to see very well if there's been a clear trend. So I'll note that most of the wells, 30 of the wells, showed increasing trends, and those are in green. Towards the west, some of the increases are likely due to recharge from the west side water bank in the West Antelope sub-area flowing into the Central Antelope sub-area. The 9 wells that had declining groundwater level trends, most of them appear to kind of stand alone, but there are 3 wells near the Plant 42 property that's circled there that show the declining trends. So zooming in on those, well 11 is the one we looked at earlier. I gave them little nicknames to make them easily identifiable on the map. We see to its north in the top right corner is a hydrograph for a USGS monitoring well that also showed a similar sharp decline leading up until the judgment implementation, and then still groundwater level declines, but much more measured and relatively stable water levels in the last few years. Towards the northwest of the plant, we did see a well that had continued groundwater level declines since 2016. And it's adjacent to 2 sets of nested monitoring wells, which means that it's a group of wells that each one is screened at a different interval. So they're telling us about the water levels at different depths in the aquifer. And you can't see them all on the map, but most of them are showing relatively stable water levels, and some of them are showing sensitive responses to nearby pumping. And so you couldn't really identify a trend. And so it's likely that the declines at this well might be more localized and may not necessarily represent a widespread trend. And so going back to this map of the water levels throughout the Central Antelope sub-area, I first just want to note that we did only look at where USGS monitoring wells have been recently monitored. And so some of them, especially towards the south, are pretty sensitive to nearby pumping. That's where a lot of municipal wells are. So we don't have as much information in this area. And then I think the takeaway message from this bird's eye view is really that even within the same sub-area, the groundwater level trends can vary and may represent local impacts. But we can also see some sort of broader trends in parts of each sub-area. Are there any questions about this?
I do. That's fine. So those declining areas, or maybe that cluster, would you say that's more of a micro effect and just for that certain area versus, I mean, it's interesting, you're seeing blue and green in a lot of areas and red in that cluster there.
Yes, it seems like because we have two wells that are showing similar trends, it's probably not hyperlocal, but it's definitely not indicative of the whole sub area. But within that area, it seems to be that's the general trend.
Thank you.
Art, in that, it's right in the Plant 42 area, I believe is where you're showing that.
Yes.
Airport. So does Plant 42 and do they actually pump water, or are they just having the wells there for the testing of the contamination?
For this, I didn't look up the production rates of the specific wells in the area.
I mean, there has to be a reason why this area, I mean, there was a lot of farming and still is, I guess, and Julie knows better than me, but to the north and to the east, and sort of to the east of there is where the tertiary water comes back to water the alfalfa fields. So it doesn't make sense we would be losing water there now anymore.
Our limits are all up on our wells.
Yeah.
We've got 4 wells in that location.
And yours are up. And Dennis, it looks like, does Palmdale Water District impact that area? Or I mean, you probably know as well as anybody, why would Plant 42 and that area be showing decreased?
Well, when we start with PWD, the PWD well field is the blue dot below those red dots.
And then that red dot.
We've been stable.
Right. What's that red dot below the blue dot to the south? Do you know?
I'm not sure where that wall is.
Okay.
It's not one of ours. The red dot that's circled and the one adjacent to it, that's the area where there is production for, I believe, Boeing. You know, all these contractors have their own wells within Plant 42 for drinking water for the people that work there.
So do they have a production right?
That's above my pay grade.
Arden, that's kind of your pay grade.
Someone from the public that would like to speak.
Oh, wait, Arden, before you speak, we might have some more information. Brandon Calandry. Oh, you're usually a board member.
Usually.
Please.
I'd like to add some context to this map. In the northwest region up there, if you look along Avenue D, there's about 4 monitoring wells there. That's because that was the former secondary water facility that they used for alfalfa for Nebuchadnezzar ranches,
right,
which was 1,700 acre feet, which is no longer in production and has not been getting used. There was a lot of farming in that northwest quadrant that is no longer in production to the tune of several thousand acres. If you look at some of those green wells out on the east side, along those paths out there, there's been quite a bit of reduction in farming, which speaks to why you see the increasing numbers on the east side. In that center area right there, that's where you have a lot of your, it's where all the houses are, industrial is, it's where you got some mutual water companies out there. That's one of the areas of greatest demand, which would speak to my opinion as to why you see stable and declining levels in that area.
What about
just off of a use standpoint, what I've seen.
What about Plant 42? And is that all due to the usage of the wells by the aircraft industry out there?
I can't speak to exactly why that is, but Plant 42 I know does have one well that they do use.
And then
that
it'll be an Arden question in a minute.
Yes.
And Julie? Kyle? Come on up.
possibly a question for Arden as well. I was just curious in that the area where you have the most declining water levels in the red, how far apart are those wells? Because I know all of us probably remember going through the adjudication and Larry Rotman telling us about, the wells needed to be, and we've always done that, a quarter to a half mile apart, or it creates a cone of depression and they all drop. All your levels drop. So I was just curious as to the location of those.
Thank you.
Yeah, I don't know the exact distance between these two wells, and I had just clipped this map. So, unfortunately, we don't have the scale on this, which is probably a big geologist red flag on my part. But I can look into that. And these are both monitoring wells that are not used for production at all.
So Arden, do you know why, or do you have any conclusions as to why the water levels are dropping in that area? Because that's what started this discussion, is when we were talking about monitoring wells and they were drying up. So why is it? Is there anything we can do about it? Who's using that water? What are their production rights? Do we know?
Yeah, so I can look into which production wells are in this area. I think it's very likely that, we see that the declining water levels, the rate of decline has diminished quite a bit. So it seems most likely to me that there are producers out there that have been producing for a long time and they've cut back their overall production rate. But it's kind of sort of a question of, are the cutbacks enough to totally stop the groundwater level declines? And I'll, once again, take it back to the slide that has the ramp down period. I think it is important to note that in the ramp down period, it was expected that it's going to take a little bit of time for the basin to get to stable water levels. And this may be an area where there, like Director Calandry had mentioned, there's just a higher density of overall production in the area, which could lead to, even with everyone pumping within their water rights, there is a potential for decline if there's a high density. So I think it's important to keep an eye on this area, but also recognize that we just got out of the ramp down period, and we should be getting either in the coming weeks or in the next month, the 2025 spring water levels from the USGS.
Okay,
so I guess I do have a comment back to you, Arden, is your comment of there's not enough cuts. If you go back to that slide where it shows increase, flat, and decrease, I would say there's maybe too much cuts. If I'm reading into this and you're maybe identifying something that's macro or micro taking place in that one area. So I take exception to the comment, and I would really push back on that the engineer isn't taking a position of what needs to be done until all the facts are reviewed. That's concerning as a landowner and as a water right holder.
Yeah, I'm sorry, what comment did I?
She said there may not be enough cuts taking place in this area.
Yeah, I think the reason we did ask Arden to do this is we saw declining water levels. It's education right now. No action is being taken, but Arden, go ahead and.
But my point, I guess just to be very clear, if you take a look at that 75, 53 of them are stable to increasing.
Yeah, no,
it's making the statement is there's not enough, reduction. It's just every landowner's hair on their back just went up with that comment.
And good point.
And I want to be clear, I wasn't making a statement about overall or any recommendation that, the safe yield is reevaluated at all. But there may be areas where there's a higher density of pumping, and we do see declines even when everyone is producing within their production rate. But that would not be applicable for the whole area.
Yeah. Arden, go ahead through the rest of your slides on this, and then I think we'll have discussion after that, okay?
Okay, this is my last slide for this item.
Oh, that was? Okay, got it. Then, obviously, you're going to keep an eye on this area. The only thing I would be interested in is what, in that area around plant 42, where the 3 wells are, is just what are the production rights there and what are the production holders there, just for more education for us. Is that something everybody's okay with? Okay, and then go on to your next topic, please.
Okay, great, thank you. So we met with council and admin to talk about what is the best way to move forward with determining how to approach the storage of carryover water after 10 years. And in our conversation, it's clear that most of the decisions are legal and administrative. And we recognize that there's risk management, and the goal is to do it in a way that is equitable to the parties. So I do just want to acknowledge that's sort of in the legal and administrative camp. However, council and admin recommended that we sort of kick off this conversation with a discussion from the Watermaster engineer of us just providing some context about physically what is carryover water representing, and also discussing it within the context of the change in groundwater volume that we've observed through the years, and sort of a comparison of the physical recharge in the basin versus the carryover and storage obligations. So first, to talk about physically what is carryover water representing. So to step back, under the judgment for native safe yield, the amount of recharge that's going into the basin the aim is to have it roughly equivalent to the volume of production rights and imported water return flow credits. So the volume coming into the basin is roughly equal to the volume that's extracted from the basin. And the Antelope Valley adjudicated basin is pretty unique out of adjudicated basins because it's assumed to be hydrogeologically closed. So what happens in the basin stays in the basin. The groundwater flows in and it's not flowing into another basin. It's not being discharged out of the basin through rivers. So in an ideal scenario, the carryover balances would represent water that's being recharged into the basin, but isn't being extracted. So the groundwater levels would increase in response to the increase in water volume from that carryover water if there's a high amount of carryover water. Another way of sort of looking at what the carryover water is representing is it's water that's accrued because production has been lower than the production rights and the imported water return flow. And so this is the annual production map from each year's annual report that we share each year. And I added the dashed line to show the sum of the native safe yield number and roughly what the imported water return flow credits have been for the last few years. And so the bars are showing at the bottom small pumping estimates and reported production. And the blue is the recovery of stored water, which is kind of not factored in when determining carryover volume. So the carryover water accrued each year after ramp down is roughly the distance from the top of that reported production bar up to the native safe yield and imported water return flow credit. And this is meant to represent water that was recharged and is in the basin but hasn't been extracted. And so we've seen this carryover water accrue each year. So right now there's 224,247 acre feet of carryover water. It's much less than folks' production rights have been used or reported to be used since the adjudication. So this carryover water has accrued. So now I'm going to shift to talking about what we've calculated as the annual change in groundwater volume. It's also referred to as the change in storage. Each year, we have two different methods. Last year, we reported both of them in the annual report, but it was recommended by the advisory committee that we transition to just reporting one volume because it's a little bit confusing to have two. But for now, I'm showing two just to have another data point. So on the right is the cumulative modeled change in storage from the beginning of 2016 through the end of 2023 using the model method. And that's been an increase of 120,600 acre feet in the basin. So overall, water levels have increased with this volume. And then the calculated spring to spring 2024 change. And that's the method that we've used in the past based on what was used in the adjudication expert report, where we look at the water levels between the 2 years and the amount that they've risen or decreased and multiply it by aquifer properties. That's a little bit higher at 244. And that tends to overestimate the recharge or recovery from banking facilities. So before 2023, it was a good bit lower than the modeled volume. So I'm bringing this up because I want to just bring attention to the volume that we've modeled or calculated using two different methods from 2016 through 2023 with the obligations that exist in the basin. So obligations, I'm using that term, paper water is sometimes referred to as water rights that may not necessarily be physically represented by physical water in the basin. So there's about 200 acre feet of stored water right now that's available for recovery. So that's the volume of water that parties have physically recharged in the basin minus the leave behind volume. And then there's the 224,000 acre feet of carryover water that's accrued, and that's through the end of 2023. We haven't yet calculated that for the new annual report. And that represents water that if the annual recharge has been equal to what the native safe yield is, or the total safe yield is in the judgment, that represents the amount of water that would be in the basin and hasn't yet been extracted. So that's 423,800 acre feet roughly. And we felt that it was important to just call attention to the difference that exists between these obligations and the modeled and calculated change in volume using two different methods. And the concern is that if all of the stored water and carryover water were used today, the basin would physically be in overdraft. So water levels would be lower than what they were at the beginning of 2016. And I just want to be clear, we are not recommending at this time reevaluating the native safe yield. The judgment says to wait until the 17th year, which would be about 2032. And we do think that at this time, waiting is appropriate to get more information. But I want to just sort of walk through the potential reasons that this deficit might exist. The first one is that each year we're getting less annual recharge than the native safe yield calculations have estimated. The first potential cause of that could be that the native recharge was overestimated in the judgment. And this comes up because this is the biggest source of uncertainty in the study and the judgment. And the USGS published a study about that time that estimated that a lower volume. Another thing is that we've had some really dry years. There's been 2 years of 5% Table A State Water Project allocations since the implementation of the judgment. And it's possible that the native safe yield was based on climatic conditions that might be dry, that might be wetter than we may see moving forward in the future. Just keeping that there's been some dry years. And then the overall decrease in irrigation and groundwater use has sort of counterintuitively led to less recharge in the basin of return flows. Another important thing to note is that we went through the ramp down period. Ramp down allowed production that was above the native safe yield. So to put it another way, even if we were getting exactly the safe yield in the judgment recharged to the basin each year, with ramp down pumping, the water levels would still decrease until they leveled out. There are parties with other rights to produce groundwater that have production rights that are outside of the native safe yield. We know that conservation efforts like water use and irrigation efficiency have decreased the percentage of water that occurs as return flows. So conservation is great, but it throws off the calculations a little bit, and that's just worth noting. There's illegal pumping. The reported production is going to be a little bit lower than what's actually occurring. There's not an incentive to report higher, right? And then finally, acknowledging that there's uncertainty in both of the modeled and calculated change in storage values. So we're bringing all of this up because from our view, it's important to keep in mind when considering continued storage of carryover water after 10 years. And we just want to raise awareness that the 10-year carryover limit does serve as a buffer to keep obligations from accruing indefinitely. And if all of the carryover and stored water were extracted at once today, which I mean, this wouldn't happen all in 1 year. I don't think there's the physical infrastructure to do that. But it would lead to declining water levels throughout the basin, depending on where it is, subsidence, and overall basin-wide overdraft. So this is the last slide I have on this topic, and I'm happy to answer any questions. But we just recommend keeping this in mind when addressing the best ways to think about moving carryover water after 10 years into storage and the potential for having sort of the difference between the obligation and what we're observing and calculating for the change in groundwater volume. Thank you. Any questions?
Any questions?
Probably more questions.
Go ahead, Derek.
I guess
Derek first, and then we'll get somebody online.
So one of my main points would be is that, and I'll look to the engineers and all the users, there's no way you could physically pump all that water in 1 year. So number one is, I think the reality that, if everybody went to the well is impossible to do. I guess my other point is you go back and you say it and you make a comment on it that paper water or paper rights or whatever that is. I would say this, the production rights of every landowner and every, Exhibit 3 and Exhibit 4 holder aren't physical. If we decide not to use those in a year and carry those over, they don't become a piece of paper. They just become something that's been carried over. And, the recharge programs that a number of these districts and private operators have, once they eliminate their loss, that's not considered paper water. That's considered physical water in the basin. So I get very concerned when we call out paper water. And, you know, this is a living model. I know every engineer that's told me is the models aren't accurate and they're, you know, they're not great, but they're as good as they can get. So we need to continue to evaluate this. And, you know, this is a dynamic basin that when it recharges, you know, it's going to take a while to resettle that. And the fact that we're pumping less water and you know, there's a comment that we're getting penalized for that from an efficiency standpoint. Well, that just has to get caught up because at some point in time, either we're going to use the water or move the water or do something with it so that efficiency will be used.
Thank you. Carolina?
Thank you. So first of all, Art, thank you for the presentation, and I especially appreciate you know, at the onset of your presentation that you were saying, you know, look, this is in no way a discussion regarding the change of the safe yield. I think you said it several times, but I'll reiterate that that's what you said. But then this is very valuable information even from then. I concur with some of the comments my fellow board member made, and that you know, these are things that need to be looked at more closely, and that they have true value in different sense, depending on who holds those rights. What I will say is that this makes me feel like this was very timely. I know we're going to hear probably from council and administration, but I appreciate the Watermaster engineer bringing this to my attention, because if nothing else, I think this further puts forth the very important need for this board to start considering how we will manage carried over water. So I think we should, you know, take some of this information and maybe some of the information being provided by council and the administrator to, again, really start considering as how we can help those that are impacted by this to understand how we can begin that agreement process.
Good comments. Anybody else? Hey,
Yeah,
Arden.
this is John. Yeah,
Oh,
this
go
is
ahead.
John.
Hi, John.
Yeah,
Go ahead.
This isn't about carryover, but it's about the basin being a closed basin. Are you agreeable to that, Arden?
Yes, there may be small amounts that flow, but of things from everything I've reviewed, it appears to be negligible. So functionally, it's a closed basin.
So you have been looking into this, and have you been looking at all about the salts and minerals that are coming into this valley from Northern California, imported water?
The salts in the imported water?
Salts and minerals that are coming out of the Northern California on imported waters, and the effect it'll have on the water quality in the Antelope Valley?
I know in some of the CEQA work that we've reviewed for storage agreements, from what I've reviewed, the water quality of the imported water doesn't differ too much, or doesn't have higher concentrations than much of the groundwater.
Is that salts and minerals? We're not bringing salts and minerals into this valley? From
I don't know how the salinity concentrations of the state water project water differs from every part of the basin. So I think that's a pretty complicated question.
Yeah, I know. I don't ask easy ones. Okay. You do realize that the only outlet to the sea from the basin is up out of the Santa Clara River, up in Acton area, that runs all the way down to the Oxnard Plains. Are you familiar with that at all?
Not specific details.
That would be an outlet. The only thing is that a brine line would have to be put in from this basin into into Santa Clara. And then,
John?
yes,
Yeah.
I think
Good
important.
question.
I just want to bring it to your attention. That's all.
We appreciate it. Thank you. And that brings us to the Sigma reporting for the Antelope Valley adjudication area. Go ahead, Arden.
Thank you. So item D, this is just very brief. So DWR requires that annual reports are submitted on April 1st. However, because of the judgment, we follow a different deadline. So our annual report is due on August 1st. And so we coordinate with DWR where we submit a letter each year in the Sigma portal or in the adjudicated basin portal just to explain that the annual report is coming by August 1st and make sure that no flags are raised by them being confused and thinking we didn't submit anything. So that letter is included in the packet. Are there any questions on this?
No questions. Go on, Arden.
Great. So the last bit of our update is just about the annual report and our schedule. So I will be sending out an email maybe this afternoon or tomorrow to agencies with data requests. If you've received one from us in the past for annual reports, be on the lookout. This is for water level, water quality. If you haven't submitted storage info already, we'll ask for it, and imported water data. So we request that folks get it back to us by April 18th, and I will be following up if you forget. This is a snapshot of our timeline for the annual report. So for March, we submitted our letter. I'm sending out the data requests. Please get the data to me by April 18th. The invoicing for the variable administrative assessments will be sent out by May 1st. So by then, we plan to have the table showing carryover water and water accounting for parties posted to the website by May 1st. I'm planning to be at the board meeting in person on May 29th. Or is it the week before that? But the May board meeting, I will be in person. And we're planning to split the annual report results into 3 presentations to try to keep them briefer. June 6th, we'll have our first draft posted on the website with an opportunity for public comment in the June meeting. And then we'll have our revised draft posted by July 3rd, once again with an opportunity for public comment and board approval in the July meeting. And everything will be submitted to DWR in the court by August 1st. Also, by the end of June, we're hoping to have sort of the trial input version of the reporting app with the goal of identifying some parties for the third quarter who would be interested in trying out the app to see how their field reporting goes with it. Are there any questions about the timeline?
Arden, May 28th is the meeting that you will be coming down in person. And just so the board knows, we will be taking a board and staff photograph on that day. So if you can be here, make sure you're going to be here for the annual report. Right, Arden?
Yes, it will be in the annual report and we're going to look amazing.
Thank you.
I said the last, oh, yes.
I really appreciate you briefing us on, the electronic application that we're going to start using. I was wondering if for further consideration, if it's possible to maybe send out that data request earlier than the end of March in order to ensure that you get responsive by mid-April.
Okay, yeah, I think for next year, we can try to send it out a little bit earlier, and I'll send it out as soon as I can.
Thank you.
Great comment. Anything else? Okay, that brings us to our general counsel's
Oh,
report.
there's one more brief update.
Oh, go ahead. I'm sorry.
So the last item is we just wanted to share our suggestion to the board that we switch to using the modeled version or the modeled calculation for the change in groundwater volume in the annual report. We were required to give DWR the annual change in groundwater volume each year. It's really the number that they track closely. And we've been using the surface difference method. And over the years, as water banking has become more prominent, this method tends to overemphasize recharge and recovery and extrapolate the highs and the lows at water banks through larger portions of the basin, leading to less accurate results. So we're recommending in this annual report only calculating the change using the modeled value instead of having two different numbers. And we also recognize that we want to coordinate with DWR and communicate with them just to make sure that if there's any issues that come up, that we're working together to make sure that everything goes smoothly. So we wanted to check in and see if there's any questions or concerns with that.
Any questions?
Yes, so thanks, Arden. So my question would be, you have several years worth of data here. How closely have these models differed, or how closely matched are they over time, and how much do they differ?
Yeah, that's a great question. So one of the big differences that you can see this plot is comparing each year. And one big difference is that the modeled version is showing the calendar year, while the surface method difference is showing spring to spring. And most of the recharge is often occurring during the winter and the spring. So there can kind of be a lag each year. You can see, especially in 2020 and 2021, that the surface difference method was overemphasizing groundwater that was extracted. And then in 2023, it had a much higher volume of groundwater that was recharged. So in recent years, they tend to show a more pronounced difference.
But looking at it over time from 2016, are they pretty closely matched?
For the most part. So I think that from 2016 through 2022, the change in storage was negative 4,000 for the model and about negative 50,000 for the surface difference method. In 2023, with the huge recharge year and widespread banking recharge, they differed quite a bit, where then this total difference from 2016 to 2023 was 120,000 for the modeled method, but then all the way up to 244,000 for the change in storage method. And the overall, the change in groundwater level method shown in green. And the value that was measured in 2023 in green for the surface difference method, it's taking into account also some of spring 2024, which is one reason why it's so large, but also the overemphasis of recharge operations as opposed to basin-wide conditions is another reason why the change is so large in 2023.
Well, I definitely concur with the use of one model. It gets very confusing when we're looking at two. And I just wanted for transparency for everybody to understand, what that might mean and how they've been compared thus far. And I do think it's important to maybe I should say it differently. Arden, do you think that the changes in climate and the variation that we're seeing is better reflected in the modeled method?
Yes, I do. In the modeled method, we're taking into account the volumes that we know are being recharged at banking facilities, and also the volumes that are extracted from pumping, and factoring in the different climate conditions, as opposed to just relying on the groundwater levels, which sometimes are more heavily weighted near banking facilities.
Thank you.
Thank you.
Any other questions? Arden, very good report. Thank you. And Craig, you're on.
Yes, we have 3 very active litigation matters that we'll discuss in closed session. A couple things. We were going to discuss the closed session issue relating to privilege. We'll do that next month. We'll work with Keith in responding to their questions and issues, and hopefully have a very full and robust discussion next month about that. I was curious whether the board wanted the legal side input on carryover, a potential template for carryover purposes. We didn't get into that in Arden's presentation, but I thought that may be something that the board is interested in.
Explain a little bit more template.
Well,
we need to start working towards what the storage agreements will look like, because it's coming up.
Right.
And what are you talking about with the template?
I'm talking about the same thing.
Same thing, okay. Yes, we do.
You want that? All right. Okay. We'll have that for next month. The last area that hasn't been responded to yet, and I'm glad that Director Calandry's in the audience, was his sub-area questions. And I've talked to Arden about this, trying to get an understanding of exactly what his questions were. I would propose that we work directly with Director Calandry to get those questions answered. Part of it was whether there's a safe yield indication for each sub-area in the judgment. What about pumping that moves around in a sub-area? How do we offset it if it's causing material injury or other issues? So we'd like to get together with him and present that in a uniform, concise way next month.
Very good.
That's it.
Okay, then that brings us to board members' requests for future agenda items. We have the RFP on. Anything else? Barry can. Sure. That brings us to closed session. Is there a motion to go into closed session? Motion made by Kathy, second by Angelica. Is there any discussion? Hearing no discussion, all in favor of the motion say aye. Aye. All opposed, motion's carried unanimously. We will be in closed session. Let's go in at 12:30. What time does the dog group come? But they'll have lunch first, right?
Yeah, they can set up.
So set up their lunch out here and we'll be. Thank you.